Welcome to another American Bankruptcy Institute studio show. I'm Sam Giordano, ABI Executive Director. We come to you today from our offices on the Potomac in Alexandria, Virginia. If you ask the average American to identify the most powerful or influential agency of the federal government, you might get several answers. Some might say the Defense Department, represented by the image of the mighty Pentagon. Others might say the Federal Reserve, with its power over the money supply. Lawyers might say the Justice Department. But if you're in the business of consumer credit or finance or debt collection or a host of other financial products or services, the most powerful agency of the government is the Consumer Financial Protection Bureau. The CFPB was created by the Dodd-Frank Act, passed in the wake of the financial crisis. The agency has broad jurisdiction over banks, credit unions, payday lenders, mortgage servicing, student loans, foreclosure relief, debt collection, and more. The agency is empowered to prescribe rules and take enforcement action with respect to dozens of consumer protection statutes. The agency is controversial in its creation and its actions, and has both ardent defenders and critics. Today we're going to explain a bit about the CFPB's role and its impact with two close observers of the agency. Alan Beckett is the managing partner with Beckett & Lee in Malvern, Pennsylvania, where she represents creditors and debt buyers in and out of bankruptcy cases. She serves on the ABI's board of directors as vice president for publications. And Joanne Needleman is with Clark Hill in Philadelphia, where she heads the Consumer Financial Services Regulatory and Compliance Group. Joanne is the immediate past president of the National Creditors Bar Association, and she also serves on the CFPB Advisory Board. Both Alan and Joanne have written about and made presentations about the CFPB to industry and legal audiences. So welcome to you both, and thanks for joining me.
Thank you. Thanks for having us.
So Joanne, let's start a little bit about the CFPB. We talked about that it was created by the Dodd-Frank Act, its formation, its structure, and its powers.
Sure. Well, I think what's the most unique about the CFPB, unlike other federal agencies, is that it has one director. The FCC, the FTC, the FDIC, most of the other agencies in Washington are run by either a commission or a board. The CFPB was very different, and intentionally so by Congress. It wanted to be a truly independent agency. And in that respect, it's very powerful. So there's one director who was appointed by President Obama, and as we saw over the years, there were some issues about his recess appointment. That was ultimately confirmed. But the director really answers to no one. They are not otherwise subject to appropriation by Congress. Although the CFPB does come to Congress twice a year to both chambers and does report about its activities, but they do so voluntarily. But their budget is not otherwise appropriated, and they're pretty much free to do whatever it is that they choose. And that makes it a very unique agency. It has it has an org chart like any other federal agency. The three probably most significant divisions of the Bureau, as I would call them sometimes, is supervision and enforcement. That's where you hear all the press about the enforcement actions and the certain markets that they're looking into. There's the regulations, markets, and research. Very interesting division where you have a group of very bright people looking at specific markets, and that research helps them develop rules for additional markets that are not otherwise subject to rules at this point. And then consumer education and response. That's where you have trying to educate consumers on financial literacy, also the complaint portal, which we'll probably talk about later, but an ability for consumers to contact the CFPB directly about certain financial institutions or non-banks that they may have a problem with, and looking to the CFPB for certain redress.
Okay. So Alan, how does the CFPB go about exercising these broad powers that Joanne mentioned?
Right. So the CFPB has power over a large number of organizations that are involved in consumer financial services. Large banks, payday lenders, residential mortgage lenders, what they call larger market participants, which they've defined as organizations with receipts over 10 million. So you're talking about debt collection agencies and the like. And they have several mechanisms over which, by which they use to exercise power over these organizations. The most comprehensive being their requirement in some cases and their ability in other cases to come in and examine the organizations.
Right.
Very thorough examination of all aspects of their compliance management systems and the way they operate in conjunction with the consumer protection statutes out there. They can engage in enforcement actions. We'll talk about some of those, and the most significant to date being consent orders that they've entered into with a lot of participants. And these are very powerful tools to ensure compliance in the absence of specific rulemaking, and we could talk about that a little bit later. They also provide guidance to industry participants, and they do this by basically explaining what they're going to do and why they think it's important, and what aspects of consumer financial services and products they think are important, and maybe providing a warning of sorts to activities they're going to be looking at closely. And finally, they have the power to issue rules under the various consumer protection statutes, which they have done in a small respect so far, but they've got a large number of statutes ahead of them that they're going to be issuing rules under, and it's a long process. So filling in the gap between the issuance of the rules is these various other mechanisms, the guidance mechanisms they have. They issue white papers. They write bulletins to the industry where they talk about things they're going to be looking at in the future, and they recap their activities in supervisory highlights, and one just came out in September, and they talk about the activities that they've been involved in. So it's a very comprehensive oversight. When they go in and examine an organization, it's a long process. They do an initial risk assessment of the organization wherein they review publicly available information about the organization, they review complaints about the organization, and they make an initial risk assessment of the organization, and then they'll schedule a review. And a review of an organization is a major undertaking. Their website discloses their review manual, and this is the guidelines for the investigators to go in and look at the organization. And if you take a look at it, you'll see it's extremely comprehensive. They look into every detail of the organization, from how its board operates to what its compliance system is, what its policies and procedures are, validation methods by which the policies and procedures are followed. Truly a tremendous undertaking to supervise these entities and to look into their practices. And finally, they'll give the entity a rating based between 1 and 5, and based on the rating, which will be a strong compliance, a strong compliance system to a very weak compliance system that requires further review. That's how the agency will be rated, and in future examinations of that organization will be based off their initial, their initial rating system.
So if you represent one of these covered persons, that's why this is important, because they have broad powers.
It is. And I think what's also important for many of the, quote, covered persons, banks, non-banks, that was a unique part of the CFPB, where traditional prudential regulators only covered banks. The CFPB covers non-banks, non-depository institutions, financial companies. And a lot of those type of institutions in the markets that they're in didn't have rules.
Right.
So they operated under, whether it be state law or maybe case law. And the difficulty a lot of anyone who could potentially be subject to the CFPB is understanding where does the compliance fall, because you don't have clear guidance. So what the CFPB did, which was unique to some agencies, is they have gone in the past 3 or 4 years to examine and supervise in markets that didn't otherwise have regulation. That makes it really hard to understand how do you comply.
Right.
So they kind of put the cart before the horse. I would have wanted in certain markets, especially in debt collection, for them to promulgate rules first, so the industry could have an understanding of where the chips may fall. But they've done that in many, many markets, and it makes it very difficult for anyone who's subject to CFPB scrutiny to know where your operation where you should be. At what level should I be compliant?
Right.
And that's ever changing, which I think we'll talk about a little bit later.
Understood. So the statute speaks in terms of unfair or deceptive acts or practices,
Right.
as being covered.
Yes.
And obviously what they're going to be looking at in terms of what your clients in your case may be up to. It also speaks in terms of abusive practices. What do these terms mean? Some of them are terms of art in consumer protection, others not so much. So explain what that means.
Well, that's interesting, Sam. We could have a conversation about what that means today, but tomorrow could mean absolutely something different. It's a very, very subjective test. It stems initially from Section 5 of the FTC Act. So the FTC had certain powers to look at companies and make sure that there was no unfair or deceptive acts or practices. And again, as you mentioned, CFPB is given an additional quality or litmus to look at, and that is abusive. The CFPB issued a bulletin about what is unfair, deceptive, and abusive. It's extremely broad.
Mm-hmm.
I don't know what it means. Ultimately, you have to look at if you're a covered person or someone who would be subject to CFPB oversight, you have to look at your operations, especially if you're consumer-centric, if you're having communications with consumer, if you're touching consumers in any way, and ensure that those practices are not otherwise harming the consumer. The problem, as I said before, is what could harm the consumer, what didn't harm the consumer today could harm the consumer tomorrow. Right. I'll use a perfect example, and in the supervisory highlights, I think really are very telling and very helpful for any industry to see what the CFPB focus is. So in debt collection, when you want to stop someone communicating with you, you have to write a letter saying stop contacting me. It's called a cease and desist, and that's what the statute mandates. But the CFPB, in looking at many examinations, has found that if companies continue to contact a consumer after an oral cease and desist, they have found that to be an abusive act. Mm-hmm. So a company going into an examination was making sure that its policies and procedures were in place for written requests to stop communicating. They weren't thinking about oral communication. Mm-hmm. So it's very hard for businesses to try to understand what is going to be important for the CFPB in any given case. Right. So it makes it an extreme challenge for many industry participants.
Right. So the financial crisis had many of its origins in mortgage products, yes. Right? And so not surprisingly, perhaps, the initial regulatory and enforcement actions of the agency were in the mortgage area, residential mortgage area. So explain a little bit about those rules and how they came to be and what their impact has been so far.
Well, clearly the CFPB and the Dodd-Frank Act itself was started because of the financial crisis in 2008, which is the direct result was because of bad mortgages. So the CFPB's first challenge was to develop rules for both mortgage lending and mortgage servicing. They have done a very thorough job along the way of developing these rules, and I will give them a compliment to the extent that they put out a first set of rules. Mm-hmm. They let the rules work for about 6 to 9 months, but there was problems. There was problems with bankruptcy, there was problems with communication, there was problems with loan modification. So they came back and they made tweaks, and they worked very well with industry to figure out where the rules worked and where they didn't. So they have tried to make sure that whatever rules ultimately happen, they're organic, they could be subject to change, and then ultimately for the industry that they can be workable. So it has been really a work in progress to how to do that. I think they still have a very long way to go when it comes to that market.
Right. So we talked about folks who are directly covered professionals who are in the debt collection business or payday lending or servicing and the like. What about CFPB activities impacting professionals and practitioners who are not directly under CFPB supervision? How are they covered?
Well, the CFPB has an interesting wrinkle to its statute in that not only are banks and non-banks considered covered persons, people who provide financial service and products, but the statute specifically says that the CFPB also has jurisdiction over service providers, and a service provider is anybody that provides provides, a material service to a covered provider. That makes their jurisdiction exceedingly broad. So if you're a company that, say, you provide copying service to a bank and you're working with consumer applications or maybe something that otherwise assists the bank in their consumer financial products and services, you're covered as well. What the CFPB has done is there's a term in law called independent contractors. Independent contractors are independent of their agent, meaning if you were to get your house painted, you would hire somebody to paint your house. You'll pick the color, but you're not going to tell them how to paint. You're not going to tell them when to paint. And if something happens, say a can of paint falls on someone that walks by your house, the painter is going to be responsible for that person getting clunked on the head by the can of paint. CFPB has pretty much done away with that. The liability now in the financial services industry runs downstream and it runs upstream. So if you're a bank and you hire people along the way, may not be your employees of the bank, you're responsible for their activities, specifically to the extent that those service providers or vendors otherwise comply with consumer financial protection law. If they don't, you could be responsible for them, as they could be. They could have an enforcement action or a consent order entered against them by the CFPB. So it's a very significant change in thinking from most other federal agencies, and just another example of their extremely broad powers.
Right. So how about lawyers and law firms and legal services providers? Are they covered by the CFPB?
So yeah,
Absolutely.
the CFPB has made it very clear that the covered persons are responsible for the actions of their service providers. So in practice, what that means is, to the extent that the CFPB goes in and examines a covered person, the covered person is going to come in and examine you in the same way.
Right.
And Joanne and I have both experienced that. I experienced that personally in my firm. My clients are spending a tremendous amount of time in my office doing probably exactly what the examiners did to them. They want to see my policies and procedures. They want to see them in action. They don't want to just read them on paper. They want to walk around the office. They want to listen to phone calls, which is probably what the CFPB did when they set up shop. And on that point, I would say that an examination, Joanne, how long would you say an examination of a large financial institution would take?
Oh, months.
Months. So
Right.
you're talking
and they'll park themselves.
providing office space for them.
Yes, they'll be there
and,
full time.
Yes.
Absolutely.
and access to your computer systems, the ability to walk around your organization and monitor what's going on. So as a law firm working for a service provider, yes. Working for a covered person, yes. I am also covered by the CFPB's supervisory authority, but I get it twice. So I get it from potentially the CFPB, hopefully not, but from the clients on an ongoing basis. So, a company with a lot of financial services clients is going to have a lot of clients in their office many times a year for many days at a time. And you almost talk about an independent contractor. The independence of what we do as lawyers is being impinged upon because of the way the structure is set up now, so that my clients don't want to tell me how to practice law, but in some cases it feels that way.
And that's ultimately what's happening. I mean, to Alan's point, I mean, unfortunately, we're not lawyers anymore. We've become vendors. We're vendors of a bank or a covered person. And let me say to your constituency that's listening to this, it doesn't matter what type of firm you are. You could be the biggest law firm in the world. If you are providing a material service to a bank, you're consulting with them. They're looking at their fair lending. They have a fair lending issue, and you're consulting with them on a fair lending issue.
Bankruptcy services.
Bankruptcy services. I mean, anything that could involve consumer financial services, no matter what size of the firm, you're technically a service provider. Now, the CFPB hasn't gone up that high up the food chain yet, but I really believe that it's only a matter of time. They're hitting the low-hanging fruit first. They're going to collection law firms. They're going to firms that do a fair amount of bankruptcy work, kind of a firm that Alan has had. Luckily, the CFPB hasn't been there yet, thankfully. But it's only a matter of time, because as they get to the higher, more, after they've gone through that level, they're going to go to the next more higher sophisticated level. So think about the law firm that consulted on the bank. We'll talk about this, about arbitration clauses. I mean, that was an issue that they consulted on, and it really impacts consumers. So I think it's just a matter of time before more law firms really get to understand that the CFPB could be knocking at their door, and have great objection to that, because, as we all know, that discussion between the client and the attorney is confidential and privileged, and the CFPB does not see it that way.
And law firms aren't used to having clients come in, and lift up the covers and ask for very detailed written materials explaining exactly how business decisions are made and statutes are followed, and how you're following statutes. And that's a big culture shock. And that happened to some of us a couple of years ago, but I see this spreading, and really to get the word out that this affects a lot more than just banks and debt collection agencies, debt buyers. But speaking of them, before we go any further, I think it's worth hearing about some of the areas that the CFPB has been involved in so far. We talked about consent orders.
Right.
So a consent order is basically, an agreement between the CFPB and the supervised entity.
And it usually stems from having had an investigation.
Sure.
So there had been a time where the CFPB had been into that entity for a period of time. Documents have been produced, testimony in the form of a deposition may have happened. And after all of that, the CFPB looks, it is an investigation of some sort. They look at that information, they decide whether they can bring an action against that particular entity. And before they do that, in most cases, there is an exception, in most cases they will go to the entity and say, all right, look, here's the evidence that we've uncovered, we're going to file a complaint, but let's settle the case. And the consent order is basically the settlement, with the entity admitting some sort of wrongdoing, not all the time, and usually civil penalties and high dollar money being paid.
Sure. I mean,
and injunctive relief sometimes.
Just recently, the CFPB advertised that it's collected $10.1 billion from these organizations. So let's talk a little bit about who they are. Large credit card issuers, large consumer lenders, particularly in terms of deceptive practices, including add-on products. These are various products can be associated with your card that were not properly disclosed to the consumer, or that the consumer was tricked into purchasing. Mortgage servicing, they've found substantial systemic abuses in mortgage servicing, mortgage lending violations, including kickbacks and mortgage modification schemes. Auto lenders, discriminatory lending, consent orders in regard to that, and deceptive.
Auto lenders, I thought they were exempt under the Dodd-Frank.
Auto dealers were exempt under Dodd-Frank, and so what the CFPB has done is looked at the auto lending industry. They just recently issued a rule defining larger participants in the auto lending industry. So if you're an auto lender and you had 10,000 applications per year, that made you a larger participant, which means now you're subject to supervision by the CFPB. So they're not saying that they don't want people to buy cars, but through the back door they're saying we're going to look very closely at the lending industry. We're going to look at the lending aspect of the auto industry. So because of, again, these broad powers, there's ways for the CFPB to kind of finesse their authority, especially in instances where those particular industries may have contact with consumers, and obviously auto lending is a huge issue for many consumers.
Yeah, it can be very costly to challenge the CFPB's authority to do what they're doing.
Yes.
So also what they're looking at, payday lenders and other short-term installment lending, debt collection practices, big deal, debt relief services, charging illegal upfront fees in most cases. And as I said, debt collection has been in the CFPB's crosshairs since the beginning. And as Joanne mentioned, the problem is we have no set of rules to follow. We have the Fair Debt Collection Practices Act, but regulations haven't been promulgated under that. So again, when you have UDAP, which is such a discretionary term, if they don't like it, it's UDAB. It's unfair, deceptive, or abusive act or practice. So there's quite a bit going on in the debt collection industry right now.
Right, right. Joanne, you mentioned arbitration.
Yep.
Very much in the news these days.
Yeah.
It's attracted a lot of attention. The CFPB's interest in regulating arbitration clauses that are common in so many consumer products.
Almost every consumer contract where there's been either money lent, that you will find an arbitration clause. I just looked at a small dollar, an online company that does lending, has affiliated with various retailers. And even in that little company, there's an arbitration agreement.
So the issue there
uses
is the agency's interest in perhaps ultimately banning mandatory arbitration. And so because it's believed, what's the argument?
Well, a few things. First of all, in Dodd-Frank itself, there was authorization for the CFPB to look at the issue, to study arbitration clauses. So that was obviously a key concern when Dodd-Frank was being formed. So the CFPB has done that. However, it's a small sampling, about 850 arbitration cases. But they have spent about a year, almost 2 years, looking at the issue. They're very, very concerned, as they were in the mortgage industry, about what does the fine print say. That has always been a real concern for the Bureau. What do consumers know when they're entering into these contracts, and what do they know they're giving up? That's the big issue with the Bureau right now. So in many of these in many of these consumer contracts, by use of the card, by use of the product or service, you're giving up your right to have your day in court. You have to go to a private arbitration. I think even more importantly, when you're giving up your right to do that, you're also giving up your right to class action. And that is a key issue for the CFPB. They are very much in favor of class actions. They feel that class actions are really, they serve two purposes. Number one, it gives the consumer a say in the process because they actually have a lawyer that would be representing them. The other thing is that class actions have known historically, in many instances, to change behavior, especially of big corporations. You saw that in the Pinto case. You saw that in the Bridgestone tire case. So in industries outside of financial services, it has had a significant impact, and maybe for some good. Financial services is a little difficult. I don't know whether class actions, based on what I've seen, have been really helpful to consumers. Most financial services class actions result in the consumers getting a coupon or getting a couple pennies. What has been beneficial for is attorneys, both for the plaintiffs and the defendants. I mean, I represent a lot of companies in defending class actions. It's great for me, but at the end of the day, is it really helping consumers? And I think that the CFPB is struggling with that issue, where to find the balance on that.
And so where do you think they're ultimately going to come out on it?
Well, right now what they've done and what they're required to do under the statute is to issue what is called an outline of proposed rule. And the outline of the proposed rule right now says that you cannot, if you're going to do an arbitration, you can't assert that arbitration, especially in a class action situation, until you go through the class action process and what is called a certification of class action is denied. Class action just doesn't happen automatically. It's a long and very expensive process. So if your certification, meaning I have the class of people who should be certified and proceed on with my case, if that's denied, then and only then can a company go the arbitration method. And if you do that arbitration method, the results of that arbitration then have to be submitted to the CFPB for further. It gives them some data to look at. That's a really expensive proposition, and some would say that that is really the unintended consequence of that is to really ban arbitration. I think that their proposals present some concern and some question. We have a Federal Arbitration Act that says arbitration is a very good thing and we approve of it. We have 2 Supreme Court cases that have approved arbitration. So I think the process now is still there's still the back and forth with the CFPB. There's been a lot of stuff in the press. There's been a lot of meetings with the CFPB. I think they're still looking at this issue and still trying to figure out what ultimately, how they can implement and give consumers more empowerment in the arbitration process.
Right. The agency's mission, charter, purpose is all about protecting consumers that need protection in the financial services marketplace.
But
These
it's also
products are
their mission also is to empower consumers to make better financial decisions,
Right.
and that's an important and I think that's where they're struggling with the arbitration issue.
Mhm.
But on the payday issue, where consumers, you have 34 million people who are unbanked.
right.
Short-term alternative dollar lending is the only recourse for this group of people
Right.
to, if they need a quick loan in an emergency, where they can do that. So there's been a lot of talk about payday. They're trying to effectively ban payday too. That's what critics would say. And part of the argument that critics would say is if you're trying to empower consumers rather than ban payday lending, shouldn't you be educating them more about payday lending?
Mhm. Well, isn't the criticism that that sort of product is inherently dangerous? That statistics show that folks just simply they never pay off the loan; they just roll it into the next payday loan, and so that at the end of the day, consumers are simply trapped in this cycle of debt acquisition. They never pay it off, and that folks really need to be protected from a product that's really almost inherently dangerous.
Well, I think then that really begs the question of the role of the Bureau. I mean, if the role of the Bureau is to empower consumers to make better financial decisions, and if you think that is a risky product, I think critics would argue that educate the consumer more about that risky product. What's interesting about payday is that many states do not have it, but the states that do have it, it's heavily regulated at the state level. There has been many Democrats from both House and Senate who have supported payday lending rules at the state level because they work. The rules themselves work and have helped consumers and protect them. So again, it's trying to find the right balance between understanding what the risk is, making consumers aware of it, but to prevent that sort of lending product, I think, goes against the mission of the Bureau as a whole.
And I think prevent is the right word because it's not an outright ban, but the regulations that are going to be imposed on payday lenders are so onerous that it's going to be impractical. It's almost
Well, it's not going to be. It's
almost
not
like
profitable. I mean, people
it's
get
right.
into business because they need to make a living. They
It's
have to
going to
make
be
their
as hard
payroll.
to give a payday loan as it is to give a mortgage.
That's right.
The debtor's going to have to demonstrate ability to pay. They're going to be limited in the number of payday loans they can take a
Right.
year. There's going to be a cooling off period between loans.
Exactly.
It's
And an interest rate limit, an APR limit.
Sure.
And APR
A debtor-
limit. So it's just
Yeah,
if there's not a for businesses to come and if the entry into market is too onerous, they're not going to come into
Right.
the market. And at the end of the day, the Bureau was developed to help those consumers. They're not helping you or I. We're educated people. We have a sense about our finances. But as in the FDCPA, there's this term called the least sophisticated consumer. That's how you determine whether your conduct is harmful. I think that the CFPB looks to helping the least sophisticated consumer, those people that don't have a way or understand how to navigate the financial services system. And I understand that. And I think that's a wonderful purpose for the Bureau. But they really need to be educating and helping consumers understand what is the best choice
Right.
for me.
instead of taking away those options altogether.
Exactly.
Right.
And those are the people that the CFPB supposedly, is there to help. I will tell you an interesting story. Over the summer, I was at a brick and mortar payday lender in Omaha, Nebraska. And it looked like an Apple store. I mean, it was a very clean store, and everybody behind the counter was wearing a suit and very, very professional. And on the wall is a chart of if I take out X amount of dollars, what are my fees going to be? And it really outlined, what the consumer was getting into. And one of the managers of the store talked about her first day on the job. A woman ran in. She was in scrubs, and she had blood all over herself. And she said, "Oh my God, my dog just got hit by a car. I have $200 in my bank account. I don't get paid till next week. I need $400 for him to have surgery. And where am I going to get $400? And she got a loan from the payday lender. She paid it back. The dog lived. So that's good news. But the point is that consumers really do an analysis in an emergency situation about where they are to get money. And with short-term alternative lending or payday lending, the fees are disclosed. And in some ways, they're cheaper than an overdraft. So a consumer says, do I go to the storefront and take out $400 and it's going to be X? Or do I go to my bank and write a check and I know that it's going to be overdrawn and that's going to be Y? That costs more money. this is the choice that I want to make. So I think consumers do more than we think that they're going to do. But again, I do approve of
Right.
of having disclosures and helping them along to make those choices. But with 34 million people unbanked or or even banked and not having the ability to get cash when they need it, and I'm not talking to buy a big screen TV, but real emergency purposes, some of these companies have they have a means.
Well, thanks very much for this conversation. This is an important agency, obviously, with broad powers. We've just scratched the surface today, and I hope we can continue our conversation more. We're starting a series in the ABI Journal on the CFPB and its role and responsibilities and the kinds of regulatory and enforcement powers that it has, and I think that will really help, our members and others who are in the consumer financial services space understand this important new agency. So thanks for being here.
Thank you for having us.
Thank you.
So that's our time for today. We thank you, as always, for joining us. You can see a variety of videos and podcasts at the ABI website, abi.org/newsroom. And until next time, this is Sam Giordano saying good day.